Are you a law school student or perhaps a business owner that is now needing some legal services and you keep running into the terms transactional, litigation, litigators, and you're wondering, what do these terms mean? I mean, isn't a lawyer, and what could possibly be different about, how one lawyer practices versus how another lawyer practices their services? Well, if you're wondering about any of these terms, then this video is for you, because in this video, I'll be breaking down some of the key differences between transactional law and litigation, okay? My name is Pamela Metani. I'm the principal lawyer and founder here at Graphene Business Law, a law firm providing business law services virtually and across Ontario to, of course, business owners, entrepreneurs, and really anybody interested in going out there and pursuing their own dream of whether it be financial freedom or putting out a really good service or product into the world, whatever your motivation is into starting your own business and running your own shop. Here at Graphene Business Law, we regularly post content on our YouTube channel that is most relevant to business owners and entrepreneurs. And of course, we have other series on the channel, such as this one, that also benefits law school students. If you're new to this channel, go ahead and click on the red subscribe button down below. And of course, give this video a thumbs up. Now, I think this video is one of those postings on our YouTube channel that truly benefits two audiences really well, and that is the law school students that might be hearing these terms for the first time, and also business owners that are also hearing these terms for the first time because maybe you're just now coming to find a need for legal services for your shop. Okay, so that's the audience I'm speaking to in this video, and both, of course, share that interest of wondering, what on earth do these terms mean? Now, as a big picture, in Canada, anybody that's studying in a Canadian law school, and I guess I'll qualify that by speaking to the type of law that I have experience with, and that's the common law structures within Canada. We know that, there's provinces like Quebec in this nation that practice civil law as well. Just because I don't have experience with that, I don't want to put out any misinformation on this channel, of course. And so I'll stick to the common law schools and practitioners and licensing path, okay? So when it comes to that, any student that has gone to law school in those, again, for the purpose of this video, common law jurisdictions and common law programs is going to come out of that Juris Doctor, assuming they've completed their articles and they've passed the 2 bar exams we have, is going to come out as a lawyer that is both a solicitor and a barrister, right? So what those two things mean is that one allows you to go to court and litigate, and the other type of lawyer is more, working on drafting agreements, on putting things together from scratch, okay? And that's also a really good way to capture the difference between transactional and litigation law. Some of the key differences, one of them is like the most humongous elephant in the room, and that's that transactional lawyers don't go to court. And that's I want to be very clear, that's a choice, right? A lawyer in Canada can choose to practice whatever kind of law, because once you pass those 2 bar exams, there's no lawyer that's gone through that conventional route of common law school, and the barrister and solicitor bar exam that is intrinsically prohibited from setting foot in a courtroom and representing a client in a trial. It doesn't work like that. And there's also no lawyer that's in the courtroom setting that's prohibited from drafting an agreement. It doesn't work like that. At Graphene Business Law, we can, of course, by virtue of I'm a barrister and a solicitor, I can represent you in court for a legal matter for your business, and I can also draft you, any super strong agreements meant to protect your business interests when you're launching something, when you're just starting a venture, whatever the case may be. There are lawyers out there that choose to, for whatever reasons, owing to personal preference, go into one path more than the other. Again, I want to be very clear. This is not because they are prohibited from doing one thing or the other. It's simply choice. Another, way that lawyers choose their practice in Canada, again, in Ontario, I'll speak to Graphene Business Law provides its business law services in Ontario. Another way we choose our practice is the type of law we offer within those two worlds of transactional versus litigation. So there is nothing that prohibits me from practicing family law or criminal law or personal injury law. It is simply my preference that, to practice business law, and so much so of a preference that our firm is literally, our slogan is all business all the time. And with the exception of a few things that I think are really important for business owners to do, like have their own will and set up trusts and things of that nature, we're really not touching other types of matters here at Graphene, strictly owing to preference. I'm a business owner myself. I consider myself very business savvy. That's just my language. And it's just so much more of a passion than any other kind of law. But that's not to say that I or any other lawyer in Ontario or Canada is intrinsically prohibited or prevented from practicing another type of law, even once they've made their choice as to litigation or transactional, okay? Another way to splice those two words is to think of it as boardroom and courtroom, okay? On the transactional front, when we're doing something in the transactional ambit of law, we are doing a lot of research. We're prepping a lot of documents. There are negotiations going back and forth before anybody is signing anything to ensure as strong as a position for our client as possible. And then, at least pre-COVID, you used to meet in a boardroom and both sides would sign, and that's transactional. What I mean by that, by the boardroom courtroom split, is that that's the boardroom conversation, okay? It's these documents that bring people together, that bring companies together. Partnership agreements we do here at Graphene, shareholder agreements, buy and sell, closings. Like, these are things that bring individuals or corporations or a mix of the two together into pursuing an endeavor, okay? Now, there's sort of one of two ways, big picture, to think about it. Once a client has satisfied their needs in that boardroom setting, we're either going to have that client go on to, live a happy, conflict-free life as pertains to the partners with whom they entered into business, or they're going to have conflicts. They'll either want to sue or they'll get sued for whatever reason. Not every time you get sued there's merit behind it. Sometimes it's literally for nothing by, a case totally without merit. Other times it might be that the client themselves has done something wrong, or they're going after somebody that has wronged them. There's 1,000,001 reasons why one might find themselves into the litigation context, okay? But once they do, what does it mean? Litigation, remembering the boardroom courtroom split, we're now in the courtroom setting. And to be clear, a fun statistic or fun fact, if you will, at least this was the exact statistic a few years ago, was that over 96% of litigated matters actually are not going to court. It's so, it can get really expensive to get to court. It can get really, really be a lengthy process. It can take years for a matter to see court, and there's so many other reasons, emotional and personal and whatever have you, that clients will settle before they get in front of a judge, and they do so over 96% of times. So just because you're a litigation lawyer or you're looking for a litigation lawyer, it's not, a one-to-one of if litigation, courtroom every time. No, almost 96% of the time you can litigate a matter and you'll never see the doors of the courtroom, okay? But for what it's worth, that's the distinction between the two types of lawyers. It's important to notice that in those pathways, there are overlapping skills, right? If we're drafting an agreement on the transactional front, of course, my team and I are going to do a lot of good research to make sure we're putting a strong agreement together for you and your business and your interests. If a client comes our way, or a client goes to any litigation lawyer because they find themselves in that context of litigation, which means lawsuit, the litigation lawyer is also going to need to have really strong research skills. Now, we might be researching different things. For example, when drafting something, you might look more at legislation or other precedents, or you might even be researching, in the due diligence sense of the other company you're getting into business with. And on the litigation front, you might be researching a lot more case law, right, and statutes and things of that sort. But it's still the same flex, the same, muscle being exercised, and that's the research muscle, okay? Both types of lawyers are also certainly going to need to have really strong writing skills, right? If I'm putting together an agreement for you, you better believe that I'm, exerting myself at max capacity to write this thing as best as I can. Not in the conventional sense of typos and grammar, that goes without saying, but in the, technical, like pure law sense of making sure we afforded you as many protections as we could. And a litigation lawyer is also going to want to write as compelling a piece as possible for those documents that are submitted to court. Your case might not make it inside of a courtroom, but it's court documents being filed every time. Those are, we start the process with what's called pleadings, statements of claim, statement of defense. And, once you're going into the court setting, then there's other documents, factums, affidavits. All of these things require superior writing skills. I would go as far to, complete the picture with, I guess, the lawyer's, skill set. We talked about writing, we talked about research, analytical thinking goes without saying. I would go as far as to say that both sides also need, fairly strong, or verbal skills. Like, the reason you hear me right now is through my words. I need to know how to speak in a way that's compelling and persuasive, goes without saying, but also correct and professional and in a way that advances your interests and that's well backed by all the things we talked about, the research and all that hard work. And same thing with the litigation lawyer in court. If you do make it there, if you don't, they're still going to need to compel or persuade the other side and their lawyer and, whatever characters are in that cast, right? So the transferable skills go without saying. It's simply the setting that is the difference, in practicing these skills. I would, I would go as far as to say that I don't think there's any purely isolated skill that a transactional or litigation lawyer is practicing that the other, a lawyer that does litigation has no idea what the skill is that the transactional guy is doing, and the transactional, guy or girl or, whatever the case may be, is practicing in a way that is, exuding the skill that the litigation person has no idea about. I don't think there can be such an isolated, unicorn skill. The difference is, it's the logistics. What setting are you in? Boardroom, courtroom. What side of your personality is showing more? What muscles are you comfortable with flexing? A lot of transactional lawyers, they have very different personalities than litigators. In one setting, also, you're going to be okay working with timelines imposed on you by, the system, so to speak, right? If we're in the litigation system, there are timelines put in place by the rules of civil procedure. There's dates the courts are setting. There's times you have to be at a certain place at a certain time set by somebody else. If you're in the transactional setting, of course, there's deadlines, of course. But, you're speaking with a client, you're coming together to set up that deadline together. The other side might impose a deadline on you. You can say, hey, a few extra days here and there. It's a different pace. It's a different way to practice, although remember, practice the same skills, okay? I'll leave this video there. I think it provides a really good overview of what some of the differences are, but also so many times when I was in law school myself, it was only the differences I heard of. And I want to make clear, if a client is out there as opposed to a law student, because a law student, as you grow within the literal law school profession and institutions, you will experience these firsthand because you have to. But for a client, it might be your first time looking for a lawyer and you might be confused about these terms. And it's not that, there's this cut line of skills that you have to worry, you know, if you got a litigator, they're somehow not as skilled as a transactional lawyer, like, oh my God, I wish they knew what a transactional lawyer knows, etc. Right? Every lawyer, from my experience with common law institutions and jurisdictions in Canada, which is like almost every province, of course Ontario, the most populated, the biggest province of business in Canada, every lawyer can do both, is qualified to do both, has been deemed competent by the law associations of that province to do both. Okay, so you're not missing out on skills in the practitioner you're hiring. It's just you, if you're looking to sue somebody, you will only be working in that litigation, you know, setting, okay? And if you're looking to draft an agreement to enter a new relationship with somebody, well, it's more the transactional flex of the same muscle that's going to be able to help you. Here at Graphene Business Law, certainly we assist business owners and entrepreneurs with drafting documents and agreements and putting strong legal protections in place for you to start your business, grow your business, and if you need to, conclude your business in a way that is most advantageous to you and your interests. There are times when even the best of agreements, you know, that may have been drafted by another lawyer, whatever the case may be, a client can come and say, hey, I'm not getting what I bargained for, I'd like to sue. And then we enter the litigation framework with still the same, you know, intelligence and knowledge and experience and skills, okay? I'll leave this video there. If you have any questions, of course, you can comment down below on this YouTube video. You can email us, and if you have any legal needs, certainly you can email us info@graphenebusinesslaw.ca, and our website, of course, graphenebusinesslaw.ca. Thank you for watching.